Okay, cool. We'll get started. Thank you all for coming. Thank you all for being here on time. So my name is Justin Stivers. I'm an attorney. I do probate, all probate law. I don't do title. I don't do real estate. All I do is probate. My law firm. If you have my card, we've actually just changed it from the name of my name to now it's called the Probate Law Firm. My email, you can still use that one, but it's also justin@probatefirm.com. And so we work with a lot of realtors. I think probate is a very kind of newish niche for realtors, and I'm seeing a lot of opportunity for you all. So I've kind of, over the past couple months, been doing this presentation to different brokerages, and it's called Probate 101 for Realtors. It's about, we'll finish in about 50 minutes, 45, 50 minutes, leave plenty of time for Q&A if you guys have any questions or answers or questions or anything. But it's really threefold. The point of the presentation is threefold. I want to, one, just give you all enough, basically how to spot when a property needs to go, when a property might be going into probate. So if you're talking with a friend or talking with a prospect, how you can identify whether or not the property needs to go through probate. The second point of the presentation is to give you all just enough knowledge so that if you go to this listing presentation, you have enough knowledge to say more or less how long you think the probate process is going to take, and maybe talk about cost, the process and all of that, because a lot of realtors don't know anything about probate or don't know too much about it. Come on in, and I think just by knowing some of the key definitions, some of the terminology, you'll be able to answer a lot of their questions and really help you all stand out from your competition. And then lastly, I want to talk a little bit about how to market for probate properties, how you all can find probate listings, because at the end of the day, that's what you guys want, is listings. For you who just walked in, if you want, you can grab some handouts right here. But what I like to do, we've got a small enough room, is just kind of go around the room real quick, brief introduction, name, how long you've been a realtor, and then if you've had any experience dealing with probate properties, either on the buying side, the selling side, maybe on a personal level, and then more or less what your experience, if you had an experience, what it was like. Start with you, ma'am.
My name is Iris Cortez. I'm a broker associate. I've been with Beachfront for 10 years. Last month I had a probate. We were the buyers, and everything went smoothly. Market title handled the buyer side, and the other side had their own attorney, so it went very well.
Okay, great.
My name is Eddie Lim. I'm a commercial business broker. 20 years with Beachfront Realty.
Oh, wow.
I also had a recent probate sale, represent the listing, the seller. Probate went well. There was a notice of homestead, final homestead, so that all the lineage sign off. So the lady, she's a widow, so she got 100%. However, when we went to market title, we hit a little bit of snags.
Okay, so yes, you've had the probate, you've had some issues with it.
I had some issues with it.
Okay. Okay, sure. Sir?
Okay, Yehuda Gamir. I'm a commercial industry. I had one time a probate a couple of years ago. Father died, and then there was a couple of children. And one of them signed. I was happy because I was sure I had the contract and everything. And the day before the closing, I called to the other agent. He said, "We're not going to close." I said, "Why?" He said, "The other children, they're not agreed."
Yeah,
I said,
very common. Yeah, that's
I
common.
was surprised. I didn't know that at the time.
Yeah.
But,
Okay. And how long have you been a realtor?
About 15, 16 years.
Okay, great. And ma'am?
Norela Guzman, 22 years realtor, working with Beachfront Realty. And I have recently, 6 months before, probate sale. But normally when I get things like that, as I don't know much, I tell my client always get a lawyer to represent you. Don't go with the same title. So she get the lawyer, and I think it's okay.
Great.
I am Carmen Yupeidad. I am an agent for 5 years. I just moved to Beachfront. I was in another company.
Okay. Any experience with probate or?
No.
Okay.
Hi,
Sonia Muriel, and Realtor for 12 years so far. But I have no experience probate, no cases on probate.
Okay.
I'm Tanya Burgess, on and off realtor for about 17 years. The reason why I'm here is I'm actually going through probate with the uncle that
Oh, wow,
left the
okay.
property from my grandmother and I, so
Okay.
I know there's a market for it.
Okay, yeah.
Sanford, I've been a realtor for 19 years. I have a situation probate going on right now. I got a listing. The son has a POA, assuming it's legal, then I put the property in the market, got a full price offer, now I can't sell it, I'm stuck.
Yeah.
And Sherry
That
from
won't
market title
work.
told me,
We need to
once
see
the
a way
son
to
died,
work.
It dies
POA
when the
died.
person dies.
Yeah, exactly. Okay, well, hopefully we'll give you some good information that you can, for both of you all, so, and yes, ma'am.
Hi, I'm Christina, I'm newly licensed. The only experience that I have with probate is when my father passed in 2016.
Okay.
And I witnessed some of the things that my mom went through, is still going through.
Sure.
And I'm new to Beachfront Realty as well. So I'm here because, seeing that, it's like a personal effect on me, so I know that
Yeah.
not only can I help, but there's also a market for it as well.
Sure, okay.
Hi, my name is Nelly. I've been a realtor for almost 3 years. And I have no experience this yet, this probate, but I'm here to learn more about.
Okay, great.
Jonathan James, broker associate, been with Beachfront now, been a broker now for about 5 years. The experience that I have with probate, we didn't close. We had a situation where the seller just kept saying that, you know, this sibling needed to approve, that sibling approved, and then all of a sudden, I know where another sibling had to approve, and another sibling had to approve.
Yeah.
So it was like a never-ending string, and then eventually my buyer said, "This is ridiculous,"
Right.
and whatever it is. So, you know, I'm here to learn more, and the one thing I really wanted to see if I could learn is what's the best way to get everyone in the room together,
Yeah.
so that decision can be made at once, as opposed to having to do exactly what, you know, that situation was, which is like, you have to agree with one person or another person, then it doesn't end up doing it.
Okay, I'll be honest, this is, well, one very experienced group. I'll say, I think the newer realtors are on the back row, which I don't know if that means but a pretty experienced group, and for a smaller group of realtors, you all have had a lot of, or have dealt with a lot of probate, it seems like. So that's I don't know, I think it kind of proves my point that probate is kind of a growing thing that you're probably likely to come across in your career. I'll touch a little bit on the sibling thing because I heard it a couple other places, so I'll save that for the end and say maybe some options, because that is one of the downfalls of probate that does, I think, give probate a bad rap in the realtor world. But okay, great. So I think very seasoned group of realtors. What I want to do, a lot of you all might know these terms, but I kind of want to just explain some key terms that you're likely going to use in dealing with probate. Again, I think just having a good working knowledge of this terminology will go a long way, and they get thrown around a lot in the wrong way. But so probate, just very generally, what probate is it's a legal process. There's the way I think about it, or the way I explain it is there's judges involved, there's courts involved, there's probably attorneys involved, and it happens after someone has passed away. So probate occurs after someone has died, and it's essentially taking what that person had, going through the court system and the legal system, the judge and everything, and at the end of the court process, the judge is going to say, okay, now that is owned by his or her beneficiaries. So whenever you hear the word probate, what that really means is there's a court case, there's judges involved, and it's just how you transfer basically anything that a person had while they were alive, and now transfer it to his or her heirs or beneficiaries. Decedent is another term very common that we use, and that just is another term for someone who's passed away. So just someone who's died in the legal world or in the probate world, we use the word decedent. Estate. This is pretty common. This word you're going to use in a lot of different ways. The way that I kind of think about an estate is it's everything, all assets, so a car, a house, bank account, and also any liability, so any credit card debt, any hospital bills that a person had when they died. So let's just say John Smith, while John is alive, we call him John Smith. When he dies, we now call him the estate of John Smith. So it's sort of like their new name. Last will and testament, I don't know, does anyone want to explain, anyone know what a last will and testament is? Have any idea? Yes, ma'am.
It's when the person was alive, they designated who they wanted to leave their assets to.
Yeah.
So
yeah.
there's a legal document that's been notarized.
Yep,
that
that's
has
pretty,
to be found.
pretty accurate. Yeah, a last will and testament, or just a will, is a document that basically that is done while a person is alive, and they say, I want, you know, my kids to get everything, I want my spouse to get everything. They'll normally name a personal representative. There are certain requirements to have a valid will, but you could basically, you know, take this piece of paper, write it, and say, I want my wife to have everything when I die, and there's certain requirements, but it could still be a will. Yes, sir?
Do you still have to go to probate?
Yeah, so we're going to talk about that, and so yes, that is a big misconception. When you have a will, you're still going to go through probate.
Correct.
A will alone does not avoid probate, but we'll talk about that as well. Then lastly, this is another term that you all will come across a lot, personal representative. I also put on, if you have the handout, I put the term executor. They mean the same thing. So it just, different states use different words. So for example, in Florida, we use personal representative. In New York, they use the word executor. It just depends what state you're dealing with. And the personal representative is just the person who gets to act on behalf of the estate. It's important for you all because the personal representative is the person who's able to sell the property. And we'll get into that, but when you're prospecting or you're looking for a potential, you know, if you find a potential listing and you find out it's going through probate, you want to make sure you're talking with the personal representative, because only the personal representative has the authority to actually sell the property. And we'll talk a little bit about that. Hey, come on in.
Justin, what about the term executrix?
It's the female term.
Female?
Yeah, it's the female. It's the female for executor. Hi, come on in.
Bonjour.
Okay, so any questions about just key definitions or anything like that? Okay, so how to determine when a probate is necessary? I'll just, yeah, come on, just grab one of each.
Just one each. Don't take two, okay?
Don't take two, only one.
Only one.
What would, when you all, let's say your friends call you, or you know, a referral source or somebody says, hey, listen, I've got Justin, he's got a piece of property for me, gives you the address, what's the first thing you all do when you hear that?
The seller's the wife.
You look it up on the, okay, look it on the MLS or look it up on the property appraiser. I would encourage you all, if you're not doing that, you guys are very seasoned, I'm sure you all are doing that as well, but look it up on the property appraiser's website. So if you're in Miami-Dade, the Miami-Dade property appraiser, Broward, Palm Beach, wherever you've got the listing at. But you look it up on the property appraiser's website. That is gonna usually tell you who the owner of the property is, right? The MLS is good, but not every realtor puts in the information 100% correctly in the MLS. They might put waterfront, and waterfront is, you know, if you like lean out your head and look around like 5 buildings, you see water. But the property appraiser's website is pretty accurate with regards to who the owner of the property is. So what I always tell people is if especially because most likely if you're going to get a probate listing, the person who refers it to you is most likely going to say, hey, listen, my friend's mom just passed away, we want to sell her property, what can we do? So at that point you would go look at the property appraiser's website. And I have a couple different examples. So let's look at first, the property address is 11309 Southwest Street, Unit 111C. So this one is a probate we handled.
Which one?
The 11309 Southwest 200th Street.
Okay.
Let me give you a couple handouts. So who is the owner of this property?
Maria,
Her
Estate
estate.
of
Estate.
Maria.
Estate.
Right. So yeah, so this property, a pretty easy way to tell, that EST means estate of. Okay, so Maria Pichardo was the owner of this property. She passed away. When she died, the property appraiser, learned that she had passed away, and a lot of times the vital statistics, they'll mail the death certificate, so that's how they learned that she had passed away. Now this property, if you were to see this on the MLS or the property appraiser's website, and you saw that EST, which stands for estate of, that means almost 99.9% this has to go through probate. So this is one that we did, and now the owner has changed. Now it's not Maria Pichardo anymore, it's her daughter. She now owns the property. But if you see this is, if you're looking up a property, you would know, you start doing a new analysis, you start thinking, okay, well this is probate, now we gotta do a little something different. So this property, if you were to get this listing, no probate was ever done, you would wanna tell your client, hey listen, before we can even do anything, we gotta start talking probate. So this is probably the most common one that you'll see.
Hey, Justin.
Yes, sir.
The executive's name doesn't appear in the property appraiser.
No.
Right? But it should appear in the MLS if you list it. Or you don't know, don't say anything.
I don't know how most realtors do that. I don't think so. I think if I was you might, and we'll get into how you want to list it, but you might see it as estate of Maria Pichardo, care of personal representative, and then their name. But I don't know how the realtor would do it in the MLS. The second one to look at, let's look at 1821 Northwest 33rd Street. So you'll see here, this one, the owner, and if you don't see it, tell me and I'll point you. But you should see under owner, about 3 lines down, you'll see Jesus Silva. Again, you've got the EST of, and then below that, you've got Midas Silva. All right, so this is another one that we did. Real life story. So this property, it's father and daughter, but father owned 50%, daughter owned the other 50%. When Jesus passed away, his 50% now needs to go through probate. Okay, so Maida, she tried to sell this property. The realtor didn't know that it needed to go through probate. They get to title, they get to closing, and title says, hey, you've got to go through probate to do Jesus's 50%. So she was the only daughter, so she ultimately inherited the property. They actually just sold it, but they had to go through probate just for Jesus. And so this is common sometimes where brother and sister maybe purchase a property, or 2 friends purchase a property as an investment property, or whatever the case may be. If they don't have the title done a correct way, which we'll talk about that a little bit, when one of the owners dies, the living owner is not going to be able to sell the property until they do a probate for the other person. So this, in this case, unfortunately, she spent a lot of time. They marketed, they tried to list it. The realtor, again, the realtor and I think the owner thought that Maida just inherited automatically her 50% because she was the only daughter. She was already on title, but because they owned it 50-50, we had to do a probate just for him, for Jesus's portion, to put it into Maida's name before she could sell it. Any questions about that? This is yes, sir.
Wouldn't an operating agreement solve that?
If it's a company, yeah. If there's a company, sometimes they'll have, but they would still have to change the title. So so if it was just for everyone else. So if you owned it as like a company and they had their own company and they had a back-end agreement that said when I die you get it, when you die I get it, they would still need to change the title.
What about if he's in a trust?
So that's what we'll talk about next. Great segue. So we'll look at the last sheet that you have with Karen Mogden, the 13926 property.
Dennis Rodman's sister.
Yeah, Dennis Rodman's sister. So this one, you see the TRS next to it, so that stands for trust. So this property will not go through probate. Okay, so this one was done correctly. She had created a trust. She retitled it, she put the name of the property in the trust, so when she passes, there's other beneficiaries that are gonna get it, and whoever she left it to, I'm not sure. It looks like another Karen Rodman, but I'm sure there's other people in the trust. They're not gonna have to go through probate. So this is one of the ways to avoid probate. And I always get a lot of questions about trust, so it's kind of like I don't want to go down too much of a rabbit hole about trust. It's a whole other complicated topic. But if your clients are looking for a way to avoid probate, a trust is a great option. There are some limitations with trust. Generally, if there's still a mortgage on the property, you can't put it in a trust. And a lot of times what people will do is they'll create a trust, they'll create the legal document, but they actually don't retitle the property. So they just create a trust, they've got, a 30-page packet of paper that says, my daughter gets the property, and then she sells it and she splits it with the other siblings, but they don't go the additional step of actually creating a new deed and putting the property in the trust, and then in that case, you're still gonna have to go through probate. So a trust is a great option, but it's definitely something that it's a little bit more sophisticated, and I would tell your clients, you need to, have someone who's able to help with that. But it is a good way to avoid probate.
Excuse me.
Yes, sir.
One more follow-up.
Yeah, absolutely.
What do you think about, what is your knowledge about international trust? Because you are talking about U.S. trust.
Yeah.
International trust is different law.
Let's do advanced class.
I personally don't know. I don't deal with trust. I deal specifically after someone's passed away. So I can't really give you too much.
So you are dealing only with the U.S. trust entities.
Well, I'm only talking about, I don't even prepare the trust myself, so I don't do the trust. But this is specifically for, yes, this would have been a trust that was done here in the U.S. So I can't really speak about international trusts, unfortunately.
Because international trust is a lot more complicated.
Yeah.
A lot more.
Yes, ma'am.
Normally, after a person passes away, how quickly does it get to the appraiser?
That varies, and that's something we were looking into recently for marketing purposes. We were trying to figure out. It depends. Sometimes people will notify them themselves. They'll tell, sometimes they'll tell for tax purposes, because now a lot of times what happens is, let's say the kids are living in the house and parents pass away, but the kids don't want to move. Well, they want to still get the homestead exemption. So they'll notify them themselves, and they kind of, shoot themselves in the foot, because then the property appraiser is like, oh, well, they don't live there. Well, now they don't get, you don't get homestead exemption until you become on title. So, I would say it usually takes at least a month, but probably a little bit longer. It doesn't happen right away.
So who notifies the appraiser?
It's usually, so Vital Statistics prepares the death certificate, and then they usually mail that to the property appraiser, or to the county. Yeah, yes, sir.
How long does the probate take approximately?
I'm gonna get into that in the next section. But any questions specifically else on how to, this is the easiest way to, the first part is, when the next section we're gonna talk about is, how to talk with your potential clients about probate. But the first step is knowing whether or not a probate is gonna be necessary. Kind of like that example with the Silvas, where that realtor, unfortunately, they got lucky, the buyer stuck around, and everything went fine, but they lost several months because they didn't know that probate needed to happen. So, I think you guys probably look at the property appraiser's website, but if you're not, I would encourage you to do that, and then just look if you see that language, a state of trust, anything like that. Yeah. Okay.
Before we go further, the previous case, you said one entity, when she passed away, she get already 50% share to one child. Why she didn't do it for the second child?
The only daughter.
No, I said that there's only 50%, but the probate is going to be for what? Because there is no heir.
I'm not sure, when I was talking about the two that were on title,
Yeah.
so let me see this to see if this answers your question. So Jesus and Maida owned the property. He owned 50%, she owned 50%, okay? He dies.
Okay.
Now, they have to do a probate for his 50% so that she can own 100%. Because she
Oh,
can't,
okay.
because she can't sell 50% of the property, so she has to do a probate for his 50% so that she can sell it.
It's my fault, I didn't
Okay,
understand.
sorry. Is that
Pay
clear?
attention.
Yeah, it's
Okay.
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 Pay attention.
No, I pay attention, is why I ask a question.
All right, so now you've determined that probate is necessary. Now you're going to the listing presentation, and the client is going to, you might be telling them, you might be in the position to tell them, hey, probate is necessary, or they might already know, and they're going to ask some questions because they're going to want to know, well, how quickly can I sell this property? How long is it going to take? How much does it cost, et cetera, et cetera. So the first thing that I would tell you when you are speaking with someone who you think may or may not be someone that may or may not be a potential client is make sure you're speaking with the right person. So a lot of times, and I maybe heard this in some of what you all were saying, but a lot of times you'll be speaking with someone and it's, a cousin. And his cousin passed away, and maybe the cousin was living in the house with this guy, and he's been taking care of him for 10, 15 years. His children abandoned him. This guy said, my cousin, he gets the property, you're gonna get the property. You spend all this time, you sign up the listing agreement and all of that. You go to probate, you find out he's not entitled to the property anyways.
Well, really the only way to find that out is you have to ask for a copy of the will.
So that is one way. What I guess the main thing, and I'll touch on that in a second, the main thing is you do want to make sure you're speaking with the right person. And so one of the first questions I would ask is, was there a will? And a will be a pretty good indicator of whether or not you're speaking with the right person. Because if John died and John says Sarah gets the property, but you're speaking with David, David doesn't have any right to sell the property, so you need to be speaking with Sarah. So what I always say, and the truth is, most people don't have a will. I don't know, just show of hands, who has a will in this room? 5, less than 50%, 40% of people have a will in this room. So most people don't have a will. A lot of people don't. That's probably higher than most. So a lot of people don't have a will. But what I would say is always ask it, and then if they say, yes, I have a will, say, do you have a copy or can you get a copy of it? Because I've seen a lot of times where, let's again keep using the same names. Let's say John died, David was taking care of John. Let's say they were brothers, and David tells you, oh yeah, John had a will, he says I get it. He says I get everything. I remember he had an attorney, they wrote a piece of paper, 10, 15 years ago. He's got, okay, well, can you get a copy of it? I don't know. I think he had a safety deposit box somewhere. He might have had it somewhere. Maybe he's telling the truth, or maybe he's mistaken. But if he can't get a copy of it, you should have some red flags going off that maybe you're not speaking with the right person. Because even if, let's say that they were brothers and they were really close, and his kids did in fact had nothing to do with him, unless there was a will, his kids are still going to get the property. So you want to make sure. So first question, ask if there was a will. Follow-up question, if there was a will, can you get a copy of it? The second question, again, just to make sure that you're speaking with the right person, is ask what your relationship was to the person who died. And the reason is, in Florida, if you don't have a will, there's a hierarchy of who gets what. So if you die, your spouse gets what you have. If you don't have a spouse, your kids get it. If your kids aren't alive, your parents get it. If your parents don't get it, your brothers and sisters don't get it. If your brothers and sisters, and it just keeps going down and down and down until you get to 3rd, 4th, 5th, 6th cousins. But you have to go through a fair amount of people before you get to a cousin, because that's a pretty common example here. So if you're speaking with a cousin and there was no will, I would say 70% of the time, that person is probably not going to inherit the property. It happens. We just got one recently, actually from a realtor. He was door knocking. He came across this lady. She was cleaning up the house. Her cousin had died. We did a complete air search, and she was the closest living relative. So she's going to inherit this property. But that's the exception. That's not usual.
Well, what do you use for a hair search? What software or website?
There's a website called airsearch.com. It's pretty, yeah. They're a little pricey. That's generally what we use. Yeah, so that's the software.
Air search.
Yeah, airsearch.com. But you, yeah.
In the state of Florida, is a will recorded with a court?
So a will is not recorded until the person dies, and then you have to file it with the court. So a lot of times people will ask me, I think he had a will, can you find it? And so for me, there's no master database to have, because you could create a will right now. You could do this piece of paper, I could notarize it, you could take it home, you put it in your safe, and that's it. And it could still be a valid will.
It has to be notarized anyway.
Generally, yes. Generally, there's certain requirements about a will. Not all the time, but that's.
Do you recognize one which is not notarized, witnesses?
I can know. Yeah, I mean, I know there's like a Florida law that says what makes a valid will, but that's it. Yeah, but yeah. So no, there's no. But to answer your question, there's no master database where I could find a will. Like if I think my parents had a will, unless I know where it's at, or if I know they had an attorney and maybe the attorney has it. Other than that, there's probably not a way for me to find it.
Because I come from Europe, and
Yeah.
in Europe we record all the wills.
Yeah, unfortunately, I think it's a great idea. Unfortunately, we don't. So ask. So again, just getting back, last thing to figure out, make sure you're speaking with the right person. Ask what the relationship was. If it's a brother, if it's a sister, if it's a kid, chances are you're speaking to the right person. But this is all to protect you, because again, you don't want to spend 3 months marketing this thing where, and people can be very persuasive. They can say, yeah, he was like my brother. Well, like my brother is not my brother. Or, he was like family to me. Well, were they actually related? So you really want to make sure that they were related, and you don't waste 3 months working on this only to find out sister hired another attorney and she's actually the one able to sell the property. Okay, any questions about determining whether or not you're speaking with the right person? But those are the questions I would ask. Was there a will? If there was, can you get a copy of it? And then what's your relationship to the person who passed away? So again, we talked a little bit about a will. It's not going to avoid probate by itself. So even if a person has a will and it says, I leave my house 50-50 to my 2 children, and they've got a will, it's valid, everything's done correctly, that a will not avoid probate. You have to either, like we talked about, do a trust, or there's other ways you can avoid it. You can do certain deeds, and I don't want to get too much into that, but I don't know if y'all are familiar with deeds, joint tenants with right of survivorship, or a ladybird deed, an enhanced life estate deed. Those are 2 types of deeds that can avoid probate, but a little outside of this scope. But those are really the only ways to avoid probate. A will itself is not going to avoid probate. So what's probably the first thing you're speaking with this client, he or she, you start telling about probate, what's the first thing you think they're going to ask?
How much does it cost?
How much does it cost? Yeah, so how much does it cost and how long does it take? I'll give you all a timeline for how long it takes. So, like anything, it can vary. And it depends. And I guess it's sort of similar to your all's business where you could have everything ready, docs are signed, ready to go, title's ready, and you're ready to close in 30 days. That ready to close in 30 days turns into 60 days, 90 days, 120 days. Stuff happens, so you can't plan for everything. So this is just a general idea. On average, a probate from start to finish lasts between 5 to 6 months, okay? That's the entire probate process, more or less. It can be a little bit shorter, it can be a little bit longer. That's from, I'm just saying now, me, the attorney working with the client, to them being done working with us. But for you all, it's not gonna last that, it shouldn't always last that long. There's a key date, or a key time you need to know. It usually takes about 1 month to get the personal representative appointed. Okay, so from the time that I'm working with, or the attorney is working with the client, we open the case with the court. In about a month, they're going to be appointed as personal representative. At that 1 month mark, and we'll talk about this in a second, but in that 1 month mark, when you have a personal representative, now I would say you all can go ahead and start listing that property. Okay? With me so far? Okay, so about a month, you've got the personal representative appointed, now you all can start trying to list that property. If the person died over 2 years ago, okay, you all could go ahead and sell that property tomorrow. And we could get it done, in a month, 2 months. So that's another important thing to know when the person died. If they died over 2 years ago, you could probably sell the property within 1 to 2 months. If the person died within 2 years, you're gonna have to wait 3 months, mandatory. There's a 3-month period from the probate case that you have to, is there like a phone ringing or something?
Where?
Yeah. So if someone died within 2 years, if that person owed money to, let's say, American Express, to Visa, to a hospital, to hospice, to wherever they might have owed money to, those creditors have a 3-month period from after the person is appointed personal representative from when they can try to make a claim and get their money back. And during those 3 months, there's nothing we can do. We can't sell the property, so you're gonna have to wait 3 months. So at that point, if the person died within, let's say, 2 years, it's probably gonna be about 4 months before you can sell the property.
Is this within that 5 to 6 month period?
Yeah, still within that 5. So I should have written it down, but you've got month 1, right? You got month 1, the personal representative is appointed. So you got month 2, we're waiting. Month 3, we're waiting. Month 4, we're waiting. Month 5, now you can sell the property.
I have a question.
Yes, sir, in that back.
Can you technically put in a contract with a representative, like let's say after the month, you say, okay, we'll make it contingent on the 3 or 4 month process. Like I have to imagine that some people would just want to get rid of it as soon as possible so that once all this stuff clears, then they could close as soon as possible. I'm not saying in all situations, but I'm sure there's some situations like that.
Yeah, so I would say in all, and we'll talk about the contract in a second.
Because I know it has to go through probate, the contract, right?
The contract has to be approved by the court. So what I always say in the contract, you should put, I wouldn't put wait the 3, 4, 5 months. I would always say subject to court approval. Very simple, subject to court approval, because that way you protect the buyer, or you protect the seller. The buyer knows that it's got to get approved by the court, and that's like, you could have, attorneys are notorious for drafting, page-long things that say one tiny little thing. I would, in what I advise realtors is just put subject to court approval, and so if you're putting in there, we're going to close in 60 days. I don't really like that because I don't know. It might not be 60 days. So that's why I say you got to have a buyer who's a little bit flexible, and that's why the better that you can explain to them that this is a process and you can kind of tell them, I think they'll get it. But you do want to have that language in there. Yeah.
When you're explaining the 5 to 6 months, that's like a full probate. But isn't there a way where if you're just if it's their homestead and the value is under a certain amount, that it's streamlined?
In theory, yes. There's what's called a summary administration, where if it's less than $75,000, you could, in theory, do it quicker. I don't even do it because I've had too many things happen where, again, I don't want to get too legal about it, but something happens and we have to convert it to the formal one, and then you just lose all this time and money. So I don't think the only thing that can make this, if we're talking about the 5 to 6 months, the only way to make that go a little bit quicker, what we've done sometimes, and again, this is 100% specific. We have probates open in I think 26 counties, so it's really dependent on the county and on the judge. Sometimes the judge, if let's say, for example, the property's in foreclosure, or it's an association and the family just doesn't have the money to pay the HOA dues, we'll say to the judge, look, judge, we know that creditor period is not up. Let us sell the property. We put that money into a restricted account until the end of that 3 months. And some judges won't allow that. Some judges still will say you've got to wait that 3 months. But a lot of them, where if there's a really sense of urgency that you have to do it, you can, after the personal representative's been appointed, you can go ahead and try to sell the property a little bit sooner.
What about the listing I had, but the son of the deceased and he has the POA? Is that listing valid?
No. A power of attorney, I think someone said it dies when the person dies.
Yeah.
So once the power, so he needs to be personal representative before he can do that. So that's a good segue into how are we doing on time?
What's the fee? What's the fee for a probate approximately from lot to line?
Yeah, can I answer that in a second? Let me just, you tee up all these good ones, so it's like, it's why I meant segue. So, how, for probate for you all is not a whole lot more difficult or more complicated than a normal listing. It's really not. I mean, the subject to court approval, that's one thing you gotta put in the contract. The other thing is how you do the listing agreement and how you do the contract. Okay, I think those are the two biggest things, and I'm gonna use like long sentences, but it's very simple. So when you are speaking with the prospective client, okay, the person who we know they're gonna be personal representative, they're not personal representative yet, but you know, you've spoken with your attorney, they've got a will, everything checks out. When you do the listing agreement, you want to sign that listing agreement, let's just say John Smith as proposed personal representative, okay? So John Smith as proposed personal representative. That's what the listing agreement is going to say, because John Smith has not yet been appointed personal representative. You know he's going to be. We're going to open a probate, but he's not been appointed personal representative yet. So the listing agreement is going to say that. John Smith as proposed personal representative. Good? Okay, so you signed the listing agreement, great. Now John has hired his probate attorney. Now they're opening the probate. I told you I don't advise. I normally tell my realtors, wait until that person is personal representative before you list the property. Because even though you have a listing agreement, John can't sell the property. You can't go to title. He can't sell it yet until he's personal representative. So, but now you've got the listing agreement, great. You're ready to go. He's got his probate attorney. Within 1 month, again, more or less, now John is the personal representative. We've gone